Attorney Dannielle Simms. I often get consultation calls where somebody might ask me something like this. I'm paying child support, and I know that my child support money is not being used towards my child. Do I have a right? Can I know what my child support money is being used on?
So I get a lot of these calls also. A lot of them are generally she's getting her hair done, she's getting her nails done, or her outfits are great, but my kid is over here barefoot or just not looking as great as she does. Guys, the short answer is no. And the advice that I generally give people pretty much in any fact scenario is you can't micromanage stupid. So in other words, you're not going to be able to get an accounting of what she's actually spending the money on. And no, you can't give the money directly to the child. And no, you can't buy stuff as opposed to paying child support. When you are dealing with court cases, specifically when judges are making orders, unless you guys have come up with some sort of an agreement to deviate for a good cause, you are paying that money directly to the Texas State Disbursement Unit, and then it is being sent out to her. If you are in a situation where you've got a child who is truly being neglected, and I mean in a way where, you kind of look at it and you go, hey, look, I really am paying child support to this person, and I'm not just relying on the fact that she's got her nails done and my child maybe has last year's flip-flops on. If you are seeing a pattern of neglect to her or to the child and not really being taken care of, then you might need to consider a modification for custody. And that's a whole other ballgame. But no, you don't just get to go, I want an accounting of everything you're spending my money on. And that's very unfortunate, but it's reality.
Attorney Dannielle Simms. So when we talk about Texas divorces, can a spouse get alimony from their future ex-spouse?
Well, the short answer is no, because here in the state of Texas, we have spousal support, not alimony. When we are considering factors for spousal support, you have to remember there's two types of spousal support. There's temporary spousal support, which is while the case is pending or the divorce is pending. And then there's final spousal support, which is after the divorce decree has been signed and the divorce has been granted. What support does a spouse have to provide to the other afterwards? Temporary support is a lot easier to get because most judges on temporary orders are trying to maintain status quo. So if you've got a party who has not always covered the bills or does not have the ability to cover the bills while the case is pending, sometimes you can get the other person, provided that they have the ability to maintain two households, if they're out of the household, to maintain the status quo by continuing to pay the bills or contribute at least some amount to what is required. When it comes down to final spousal support, you're looking at things like the duration of the marriage. In other words, have they been married at least 10 years? Or is there some sort of disability that was diagnosed during the marriage? Does the other person have the ability to work? Have they tried to work? You're looking at things like that. So when it comes down to alimony, you're not getting alimony, but we can explore spousal support.
Attorney Dannielle Simms. So I often get phone calls from potential clients who are looking to do a divorce and they're still living together with their spouse. So are they able to do that during the divorce case?
They can. I mean, let's call it what it is. Divorces, you generally don't want to be with the person that you are married to, right? And so you'll find a lot of situations where people are like, get that person out of my house. If you do have parties that are able to be amicable while the divorce is pending and they really just want to divide their assets and or make agreements when it comes down to custody, but they're okay residing together while the process is going on, that's fine. I mean, look at times right now, it's not easy to be able to afford to maintain two households. And sometimes you have people that truly need double income while they're trying to decide their future. Now, when it comes down to it, though, what you often have are people that cannot reside together because the relationship is just broken. A lot of times courts will consider, especially if you have children, courts will consider who gets custody of those children while the case is pending. And courts do not like to displace children. Courts do not like to disrupt the lives of kids based on the actions of adults. So oftentimes, if one person has custody of the children, that's the person that's going to stay in the marital home just so the kids don't get displaced. They're also, going to look at things like, do you have the ability to maintain the bills on the house? If you do or do not, that could be a determination whether or not you stay in the home. You also have family violence. If there's family violence in the house, the perpetrator oftentimes can be kicked out of the home and maybe subject to paying the bills in that house. So it really just depends. But ultimately, at the end of the day, one of the things that you need to consider is, yes, you guys can agree to continue to stay together, but where those kids remain or who designates their primary residence is going to make a determination while the case is pending.
Attorney Dannielle Simms, the issue of geographic restrictions often comes up in custody orders in Texas. But here's a question. Why do they exist in the first place? Why do we have them?
So, in answering your question, if you asked a client of mine, why do we have geographic restrictions? A lot of times they will respond and say, because the other party wants to control me, because the other party doesn't want me to move on. No, in the eyes of the family courts, it's to facilitate and make sure that the relationship between parents and children always continues despite the breakup of the parents. What you are trying to do is make sure that each parent has the ability to see that child. So if you have a standard possession order and you allow one parent to be able to move off to Timbuktu while the divorce was out of Texas, it makes it virtually impossible for the other parent to see their child. So that is why most times you will see a geographic restriction that says the county in which you were divorced, or the county in which the custody order came to be, and contiguous counties. What contiguous counties means is every county that touches that county where the divorce or the custody order came from, that's where the child is allowed to live within. Keep in mind, the geographic restriction is just for the child, not necessarily for the parents, but please understand that if you move and you're the one that designates the primary residence of that child and you bust that geo restriction, you are in violation of the court order. Just like the other way around. If you are a parent who has a visitation schedule and you move outside of that geo restriction, depending on what the language says, it could automatically lift the geo restriction, which then gets rid of it for the other party, meaning they can move to Timbuktu and not be in violation of the court order.
Attorney Dannielle Simms, adoption cases are oftentimes some of the most rewarding types of family law cases. However, there may be some difficulties. What is one of the roadblocks that you commonly see in adoption cases?
The biggest roadblock that I see in actually finalizing or getting a adoption case even started is locating of the parents. A lot of times what will happen is I have people come into my office and they say, this child has lived with me for X amount of years and I just want to go ahead and adopt them. And right, you're taking the legal way of just doing what you've been doing for maybe years, months, whatever. But if you can't find either one of those parents, we have to get those parents served. In the law, notice is required. Any kind of lawsuit that you've got to have a right to be served. You got to have a right to know what's going on. You've got to have a right to respond. Adoptions are no different. I don't care how long the parents have been gone. Now, granted, there's different ways of getting folks served and different ways of getting people located. But one of the bigger issues is when I come in and I see that I've got a party that's saying, well, I can't find the dad, or the dad has never been involved, because that's usually what it is. Not that men are not involved, but in these particular scenarios, it is, hey, this dad is not involved, or DNA hasn't been established, or things of that nature. It doesn't mean that we don't need to locate the father. It doesn't mean that we don't need to make efforts. It doesn't mean that they're not entitled to service. So guys, you have to know where these parents are, or at least know someone who can help you find them, or at least tell me where they used to be.
Attorney Dannielle Simms. So when it comes to the topic of alimony, also called spousal support in Texas, there are a lot of myths going around. Give us 3 myths that you commonly hear about this topic.
The first myth that I commonly hear is that it's supposed to maintain the lifestyle that you are accustomed to. It's not. Spousal support is designed to meet your minimum reasonable needs. So, for example, if you are used to living a lavish lifestyle, and your spouse is ordered to pay you spousal support, especially after the divorce is finalized, it doesn't mean that you're going to maintain the same level, which then brings me into my next myth that you will never have to work if you are awarded spousal support. That's just not accurate. Part of what the court will consider when making a determination of whether or not you are eligible for spousal support, absent, a disability or things of that nature, is whether or not you are actually going to make the effort to go and work so you don't get awarded spousal support forever. Here in Texas specifically, we are a state that we're not that friendly to spousal support. It's not that it's impossible. It's just that when we are issuing it, we take kind of, a conservative role in that. And so that's one of the myths, is that you'll never have to work, because you will. They're going to look at your ability to work and any efforts that you have made to work. The other thing is that you'll get it forever. Very rare will you see spousal support going forever. And in fact, I've seen spousal support going as short as 3 months. again, if you've got a disability that you incurred during the marriage, you might consider, some long-term spousal support. Otherwise, it's going to be for a finite period of time. So often I have to help clients transition into life after spousal support.
Attorney Dannielle Simms, we often talk about men versus women, moms versus dads in custody battles. But is it possible or likely for a father to get custody of a child?
It's absolutely possible for a dad to get custody of a child. I would like for everyone to get rid of this myth of only women get custody of children. That's just not accurate. Everything is going to boil down to your facts. I once had a case very recently where we had the facts on our side. I was representing dad. He ultimately got custody, and the mom stood up and said, well, doesn't Texas consider moms as primary? The answer to that is no. At the end of the day, the judge is going to be looking at things like best interests for that child. Okay. And if the father suits that child's best interest, he can absolutely be named as the person that designates that child's primary residence. It's not a battle of the sexes in court. It is who is meeting that child's needs. That's it.
Attorney Dannielle Simms, one of the questions I get often are from people who ask me, do I need a lawyer when I'm going to the Attorney General's court for child support? What do you tell them?
Yes. Whenever somebody asks me, do I need a lawyer? If you ask me that question, the answer is always yes. And of course, is it self-serving for me to say, yes, have a lawyer? Of course. But ultimately, if you're ever questioning whether or not you need an attorney, you do. Because a lot of times what attorneys do is they go in there and they navigate the environment for you. They're able to interpret things for you that you may not understand or you may not be comfortable with. Sure, the attorney general, they have one thought process in mind, which is let's calculate child support and let's make sure that it's paid and let's do the math. But that doesn't necessarily mean that you need to just follow what the attorney general is saying. Sometimes you are, especially when you're dealing with child support court, specifically 4D court or child support court as it is, you are dealing with officers within the attorney general when you are negotiating and coming up with those agreements. Those people sometimes are not attorneys. You also don't know if you're dealing with somebody who has a specific, well, I'm going to really fight for the person that is going to get the child support. Just like vice versa, you don't necessarily know that that person that you're dealing with won't be swayed by the other parent. So having someone there that can advocate on your behalf or at least interpret things for you is always best. So the short answer is yes, you should have an attorney.
Attorney Dannielle Simms, what do parents in Texas need to know about making education decisions over children?
Well, often what happens is you will have a party come in and say, I want exclusive educational decision-making power. Most of the times what they mean is, I want to be able to say where the child goes to school. There's a difference between making educational decisions for the child and enrollment decisions. Most parties you will see have children that are in public school, for example. So if you have someone that's designating the child's primary residence, that's generally that ISD that person is in, that school district is generally where the kid will go. However, I do like to distinguish between enrollment and educational decisions. For example, I had a case where mom had the exclusive right to designate primary residence, but she kept bouncing the kid around from school to school. So we carved out that enrollment had to be subject to agreement of the other parent, and that before any withdrawals, the other parent had to agree. And that kept the child very consistent and made sure that mom was not able to bounce the child around. Now, when it comes down to educational decisions, it's not just about enrollment. You're looking at things like, will this child skip a grade? Will this child take a sex education class? Will this child get into the special education program that they have? Will this child be gifted and talented? Those types of things, if you can't make those decisions together, you might end up in a situation where one parent has the exclusive right to make that decision, or you might end up in a situation where you guys have to come to an agreement. And if you don't, then you will follow the original recommendation of the educator or the counselor.
Attorney Dannielle Simms, doesn't the other parent have to tell me when they're traveling with our child?
Well, again, the lawyer answer is it depends. When you're dealing with domestic travel, meaning you're traveling within the United States, not necessarily. It would be nice if they did. It's always good to co-parent. But if I'm just taking kiddo up to Oklahoma and it's my period of possession, you can't dictate what I do during my period of possession. And unless there's a specific provision within your order that requires itineraries being shared or someone telling you that they're traveling domestically, they generally don't have to. Now, the flip side is with international travel, yes, because there's such things as passport provisions. There's such things as you having to sign off, you being the parent that's not in possession of the child, having to sign off on the international travel. We have so many issues as it relates to international abduction that now Texas just requires everybody to sign off on sign off on international travel, which means often that you have to tell the other parent the dates in which you intend to travel. You have to give them at least some idea of an itinerary of where you're going, and you have to get them to give you written permission. Oftentimes what you will find is that even when it comes down to the surrendering of the passport, in order to have that parent give the passport to you, if they're the one in possession, you have to provide them with certain information, and then they have to give you the passport and the permission within a certain amount of days, and vice versa. So when it comes down to international travel, yes, you got to tell the other parent or that kid isn't going anywhere. Comes down to domestic, no, if they want to take them to Disney and it's their time, they can take them.
Attorney Dannielle Simms, what are the most common reasons in your experience that people file for adoptions in Texas?
Well, when people are calling my office seeking an adoption, there's generally two scenarios that I run into a lot. The first scenario is you have a step parent who has been around for quite some time, and the biological parent they are not married to is often deceased. And so you will see them come in and say, hey, I want to adopt so-and-so's mother or father is no longer living. I've been here for a few years and we just want to, name me legally as their parent should something happen in the future. That happens a lot. The other thing that I see is you have parties who have been raising a child for a relative of theirs or even a close friend of theirs for years, and that particular relative is either not involved or is missing in action or is heavily on drugs, something of that nature. And so therefore, they don't really contribute to the child's rearing. And as that child gets older, when that adult who is actually raising the child wants to make educational, medical decisions for the child, or even seek services for the child, they run into impediments because they are not actually the child's parent. And so under those two scenarios, that's what I see a lot. What I do often have to do, especially if I have someone who does not have a deceased parent where we can clearly show this is a death certificate, when I'm looking at my second scenario, I have to remind the person, do you know where that individual is? Is this an adoption case? Do we have termination grounds? Or is it just a custody case where we can name you as a person that designates primary residence and gives you the rights to make decisions for the child?
Attorney Dannielle Simms, how do I get a judge to give me full custody in Texas?
Well, you don't get a judge to give you full custody in Texas. This is why it's imperative that people hire attorneys, because you do need to learn the legal jargon and actually get an idea of what you actually want. There's sole managing conservatorship in Texas, which gives you some exclusive decision-making powers. There are still decision-making powers that the other parent will have as a possessory conservator. And then there's joint managing conservator, which kind of puts you guys on equal footing, but you can move your rights and duties around, and some may have exclusive to certain things, or you guys may have joint or independent. That's why it's imperative for you to have an attorney that you're talking to. So when it comes down to sole custody, I often find that means that people are asking that they are the person that makes all decisions as it relates to the child. And oftentimes it translates to the other person doesn't even have visits. Now, getting in a situation where you are divesting another party of their ability to have visitation with their child is very, very difficult. So being able to flesh that out, being able to figure out exactly what you want and know what is actually reasonable and what's available to you will depend heavily on your facts.
Attorney Dannielle Simms, tell us, what do parents need to know when it comes to making medical decisions over children?
When people call my office, they generally want to know if the other parent has the exclusive right to make medical decisions involving the child, what can they do or what can the other person not do? People need to understand that when it comes down to a person having exclusive decision making for medical, they are generally talking about invasive medical procedures, meaning will that child be put under? Are they going to be doing some kind of surgery? The most typical thing that you'll see is tonsils, things dealing with ear, nose, and throat types of surgeries. That's generally what it is. And when it comes down to the day-to-day, take kiddo to the pediatrician because kiddo has a stuffed nose or has a flu, or if you're in a situation where child has an emergency, let's say child breaks their leg and that leg needs to be taken care of right away, the other parent is allowed to get that done. They are allowed to take that child in. Now, when they take that child in, if we find out that the kid has an issue with the appendix and that needs to be operated on, the other party needs to make that decision if it's not an emergency. But I do think that the common misconception is that if the other parent has exclusive right to make decisions involving medical procedures, that it is not invasive. When you look at those orders, it says invasive, okay? And it says it for a reason.
Attorney Dannielle Simms, you and I have participated in countless mediations. So here's a question. If somebody agrees to a mediation agreement when they sign off, can they change their mind after the fact?
So when you are at mediation and you are coming up with a mediated settlement agreement and you guys have come up with said agreement and it's been circulated for your review, one of the top things that you will see or should see on page 1 of that mediated settlement agreement is that it's irrevocable. The reason that mediated settlement agreements are irrevocable is because either side, it requires both parties when they are making decisions to make good faith decisions. The whole idea behind a mediation is that you guys can settle and not have to then turn around and run to court because someone changed their mind at the end. They are irrevocable. Are there ways to get around a mediated settlement agreement? Sure, but that's a topic for a different day, and that generally requires some sort of duress. Sometimes you'll see situations where a person is under the influence, and that's how you got around the mediated settlement agreement, or there are new facts. With that being said, buyer's remorse is absolutely common. I always tell my clients that when they come to an agreement at mediation, they will always the very next day, or heck, sometimes a few hours later, have buyer's remorse because you turn around and go, did I leave something on the table? Did I give too much? The long answer is, can I change my mind on an MSA just based on solely changing? The short answer, based solely on changing my mind for an MSA is no, you cannot. But please note that it's not uncommon. And when I'm actually mediating cases, what I tell parties is, when you guys leave here, you should both hate me because you are both starting at different ends of your position. And my job is to drag you guys, sometimes kicking and screaming, to the middle. So if you hate me by the end of the mediation, if both of you hate me, I know I've done my job.